492 at 508, para 31. Volume 13, 492 at 508, para 13. 31, para 31.
PDF 508.
Sorry, my lord.
PDF 508.
Yes, ma'am.
So the way PDF number?
Volume 13, page 492 at 508, para 31. Which I read. I'm
Yes,
just
you read
wanting
it, yeah.
one line to be read again to buttress my point.
508.
Lordships may see last 10 lines of that para 31. Last 10 lines. That's not very crucial because that's exactly what has happened. 370 is a clear, I would say, reflection of this viewpoint that 8 justices of this court have taken.
Running page 6038.
My lords have got it?
1 minute, my lord. 6038 running page.
Where is the young intern?
We are also in the same.
I know, but there was a young intern who was helping Justice Call here.
At least I'm trying to do it. Myself. Justice Call and me are totally newcomers to this.
Beware of my lordship justice. He doesn't appreciate those of us who are technologically challenged.
So they've become pros now. My two brothers have become pros. Brother Suryakant, I had indoctrinated when we sat together for 2 years. We were together on the
learning experience even yesterday evening while going home.
But yeah, my Lord Justice Khanna would remember Delhi High Court started it much earlier. That's why those judges from Delhi High Court are extremely pro.
We've been used to it.
Yes.
Been used to it. I think for regular matters, I found it to be extremely helpful. It's very convenient.
I skipped it.
See, some state governments are very supportive. Others, are. I remember the time of the pandemic. I won't name the High Court. They didn't have money to pay for the licenses for this video platform that we were in. So it's so dust cheap. We just withdrew some licenses from the Supreme Court and transferred it to them because they were absolutely in a dire state. And at that time, there was a lockdown. It was impossible to run the court without video conferencing.
But if your lordships can carry this into the lowest of the courts, Mofizil courts, it would be the greatest contribution
now,
that your lordships
phase 3, we have a huge budget, so we are in the process of doing that, setting up our own cloud software for video conferencing.
And your lordships, there will be at least continuity since all your lordships are here for at least next several years. So, now last 10 lines of this para. This power it may be added. The words "this power it may be added." My lords have it?
Yes.
This power it may be added is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question as to how treaties can be made by a sovereign state in regard to a cession of national territory and how treaties when made can be implemented would be governed by the provisions in the constitution of the country. Stated broadly, the treaty-making power would have to be exercised in the manner contemplated by the constitution and subject to the limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on provisions of the constitution itself. Now, Lord, in my respectful submission, the treaty in question here between the erstwhile ruler and the Governor General, which ultimately, that has now been transfixed into Article 370. So, Lord, 370 is an extraordinarily unusual provision. It's never, Lord, it's something which is so beautiful that, Lord, the constitutional framers felt that how do we give, Lord, a kind of respect, kind of acceptability, kind of, Lord, validity to this, Lord, letter of accession. So they devised, as I said yesterday, it was an absolute brilliant statesmanship on their part to bring that into constitution to assure people of Jammu and Kashmir that we mean what we say. We are not going to do away with this. So that's why this is very important that treaty will have to be interpreted in the light of 370. It's now virtually transposed into Article 370. Now, Lord, in the light of this discussion, please see, Lord, at page para therefore, our conclusion is para 44, below. Page 515, para 44, just first sentence. And this becomes even more important now. Therefore, our conclusion is, and Lord, in my respectful submission, Lord, no, it's a view which is, Lord, inescapable, and Lord, it binds your Lordship, since, Lord, this is a judgment of a bench of 8 learned judges. Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purpose of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that law necessary to implement the agreement has to be passed under 368. Now, concession follows the conclusion. So, Lord, it can't be said that it is on a concession. The conclusion of your Lordship is very categorical that legislative power is not possible. Only a constituent power can be exercised in respect of this. And that constituent power is under 368. So, Lord, in my respectful submission, far from President exercising the powers, and I will show, Lord, why President had become functus officio. But, Lord, even assuming that, Lord, 373 survives, which it doesn't, in my respectful submission, even then, Lord, the power could only be exercised under the constituent power. No other way. Now, Lord, please. Yes. Lord, this is a little important because your Lordship rightly, Lord, raised the issue as to, Lord, the definition of union territories in Article 3. Lord, originally it was not there. It was brought subsequently by, I think, 17th Amendment to the Constitution. But your Lordship said states do not include territories. Kindly see that. Page 516, paragraph 47. It would not be out of place to mention one more point before we formulate our opinion on questions referred to us. We have already noticed that under the proviso to Article 3 of the Constitution, it is prescribed that where proposal contained in bill affects the area, boundaries, or name of any of the states, the bill has to be referred by the President to the legislature of that state for its use. Therefore, within such period, it is prescribed, it has been heard before us, so and so. Then, Lord, no, I'm sorry. I'm sorry. I missed that page. It's earlier page. It is significant that Article 3. It is significant that Article 3 page 513. My apologies, sincere apologies. Page 513, para 40. My sincere apologies. It is significant that Article 3 in terms does not refer to the union territories. And so, whether or not they are included in the last clause of Article 3A, there is no doubt they are outside the purview of Article 3B, C, D, and E. In other words, if an increase or diminution in the areas of the union territories is contemplated, or alienation of their boundaries or names is proposed, it cannot be effected by law relatable to Article 3. This position would be of considerable assistance in interpreting Article 3C. So, the Lord Parliament then, Lord, amended, and 18th Amendment. That's the joy of having somebody like Lord Gopal sitting next to us. I must, Lord, confess to your Lordships that I have sufficiently been instructed, briefed, and educated by Mr. Prashant Bhushal in this matter over several, Lord, sessions. So, because, Lord, he is appearing with me, and so, Lord, it's something which I must, Lord, say that it is. Now, Lord, please turn back to that para that I was reading, para 47 at 516, and your Lordships will find in the middle somewhere on the other hand, which is at 10th line from the top, on the other hand. page 5 and 6, para 47 in the middle somewhere, or 10th line from the top. On the other hand, it is clear that if the law in regard to implementation of the agreement is to be passed under Article 368, it has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house. And that is a safeguard provided by the article in matters of this kind. Please see the language. Well, this is the protection your lordships have extended. And I beseech your lordships to extend it further. Beseech your lordships to extend this further. That this is how you can't resort to some kind of executive power, authorize president to do this, do away with everything that Article 3 provides in the garb of 356 powers. It makes complete mockery of constitutional safeguards. Because your lordship knows what majorities can do. We have seen what happened in 1975. So this is the check, and that's why constitutionalism. Your lordship's duty to the constitution, to ensure that it is upheld by the executive and parliament in letter and spirit. If they don't do it in letter and spirit, this court will strike it down and must. So these words, I now see answers to the reference which was sent by the Honorable President. We would accordingly answer.
Everybody was decided at a time when explanation 1 and explanation 2 were not on the constitutional.
They came as a consequence. Your lordship said.
They came as a consequence of Berubari.
Correct.
To take into account what the court held, that the state would not include a union territory.
Correct.
So now really that issue will not survive because the whole basis was that state will not include the union territory. And therefore, you couldn't see that territory in exercise of the lawmaking power under Article 3. You had to amend the constitution.
That's what there are two submissions on this. One, that treaty to be interpreted in the light of what constitution provides in respect of that treaty. And two, that if you want to now touch that treaty, you cannot do it by a legislative act. You have to do it in exercise of a constituent power. As I said, constitution is durable. But if it served the need of the hour on that day, doesn't mean that that need must be wished away because you have a majority. Lord, in my respectful submission, the argument that Lord government is advancing before Lordships, Lord, does not bear out from plain reading of the constitutional provision. Now see, Lord, chapter 21, the title, temporary, transitional and special provisions. Now, Lord, I accept that 370 is temporary because it's titled temporary.
Yeah.
But it is temporary from the perspective of J&K, not temporary from the perspective of the Indian Dominion or Indian Republic. The choice was left to the Constituent Assembly and therefore the people of J&K to decide whether you want to continue with this status or you want to be away from India. That was the choice. And I will show that note from Mr. Iyengar's, Gopalaswamy Iyengar's plot, a very express statement before the Constituent Assembly. So, Lord, he was chairing the committee which drafted Article 370. There were 8 members in it. And they did it because of the extraordinary situation. They realized that we are losing J&K out of our hands. Now you persuade, Lord, citizens of a state, a country, at that time an independent state, to cede to you. They agree to session on clear
There is
understanding.
a question of persuasion by,
Sorry.
it was the Raja Hari Singh who requested the government of India that
I
time.
agree. No question about
You are
it. But
saying
the
that
conditions,
if-
historical conditions can't be lost sight of. Your lordships are right. Raja requested, but in that letter he expressly asked for this protection. In that letter, he expressly asked for this protection. The Governor General agreed to that. And that is why the Constituent Assembly debated.
That's what Mrs. Sibal argued that after 1954, this 370 has become a permanent
Yes.
feature of the constitution.
Now just see, Lord. Just see, Lord, 370. Lord, 370 is, Lord, what? Lord, first and foremost, 370 is, Lord, that, Lord, Article 371C is most important. That's first. The provisions of Article 1 and of this article shall apply in relation to that state. Meaning thereby, all other articles will not apply. That's an emphatic statement in the Constitution. Article 371C. We have to begin journey of 370 with that. Then, Lord, they go forward and say in Article, Lord, B, power of Parliament, in Article B2, just a second, in Article, Lord, after that in D, such other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. So, Lord, only Article 1 and Article 370 were expressly applied. All other articles were to be applied by the President, subject to this exercise of power under D. And read with the proviso, provided no such order which relates to matters specified in instrument of accession shall be issued except in consultation. So if it is part of instrument of accession, in consultation. If it is outside an instrument of accession, concurrence of the state government. Now, state government here must be understood in the context of democracy. It cannot be understood in the context of 356 and governor exercising omnipotent powers. That's why it is not very important for your lordships to read this in letter and spirit. So, Lord, the constitutional provisions are now added by 1C and 1D. The legislative powers are added by 371A. 1A and specifically B. The power of Parliament to make laws shall be limited. Please see the words. Shall be limited, mandatory, to those matters in Union list and the concurrent list, which in consultation with government of state are declared by President to correspond to matters specified in instrument of accession, governing accession of state to the dominion of India as matters with respect to which dominion legislature may make laws for that. And 2, such other matters in the said list as with the concurrence of government of state, President may by order specify. Now, my lord, why is it temporary? Please see sub-article 2. Please see sub-article 2. If concurrence of government of state referred to in para 2 of subclause B, that is legislative power of clause 1, or in the second proviso to subclause D of that clause, that's constitutional provisions, be given before Constituent Assembly for the purpose of framing Constitution is convened, it shall be placed before such assembly for such decision as it may take thereon. Why? Because not democracy. You could only do it if Constituent Assembly approved it. It was a temporary provision. So the new Constituent Assembly is being now convened, and soon it may mean in the meanwhile, my lord, President may exercise powers in consultation with the state government under 1B or my lord 1C or 1D. They said, yes, they can. But you place them before Constituent Assembly for a post facto approval. So, my lord, it was never intended to be permanent. It is a temporary provision. And my lord, the entire burden or entire onus or entire responsibility or entire power decision to make the applicability was left to the Constituent Assembly. This can't be wished away. This what is a constitutional provision. President can't exercise powers like this and say 370 is now otiose, or it stands repealed, or it stands withdrawn. Now, in that context, please see Article 3, sub-article 3. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative. So, Lord, he can either say it will be cease to be operative, or he can continue, or shall be operative, which means shall be continued, only with such exceptions and modifications, and from such date as he may specify. So, Lord, the power is both for President to continue or President to discontinue. Lord, if he wants to continue, we can continue in same fashion or with such exceptions and modification. But for President to do so, prior consent of the Constituent Assembly is a must, provided that the recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before President issues such a notification. So, Constituent Assembly will send a notification to the President or a resolution, and on that President alone can act. You can't rewrite this. It is not capable of any other understanding. It was therefore an exercise which was limited by therefore an exercise which brought a temporary provision, but temporary in terms of the objects, temporary in terms of the actions to be taken, not by efflux of time. But time becomes important because the life of Constituent Assembly was only till 1957. Now, Lord, Constituent Assembly, as your lordships have been told, Lord, went into it in Kashmir. They said, we want to be part of India. We want Constitution of India to apply to us. We want Article 370 to continue. President accepted that and issued Lord CO in 1954. End of the matter. Where does he then have power to re-exercise that rule? It will be travesty of justice if not it is now today contended by Government of India responsibly before this court that no, it has happened. But now Governor can send in and we can act on it. Well, that will be virtually not destroying this very express provision. And I respectfully submit that it is impossible to not accede to that interpretation. It was a one-time exercise. It was not intended to be exercised again and again. Even Constituent Assembly was not given power to do it again and again. Supposing they passed a resolution later saying, now we don't want to get out of India and 370 should not apply to us. Was it permissible? In my respectful submission, no. So your lordships will have to look at it either way. That's why the word temporary is very meaningful as the heading of the article. So I respectfully submit that this article has lived its life, has achieved its purpose. Now 371 survives because tomorrow a constitution is amended and new article is inserted, which we would like to apply to Jammu and Kashmir also. President then seeks the government's view and then extends the article. So to that limited extent, perhaps this article 371 may be necessary. But 373 is very clear that applicability of Constitution of India per se was only in terms of Article 373. And once they decide that, then no, it is untouchable. It cannot be revisited. President became functus officio in 1954, so far as 373 is concerned. And your lordships have expressly accepted this position. In Premnath and Sampath Kumar, both your lordships have accepted this interpretation. I'll make it good to your lordships. Expressly, your lordships have said that. And that is not the view. Now just turn to the view of Gopalaswamy Iyengar. As your lordships would recall, Gopalaswamy Iyengar was the Diwan or Prime Minister of Jammu and Kashmir for many years. He was later defense minister in post-independent India and one of the most respected Indians at that point of time. He was heading this. Now just see his page, PDF page. Which volume? Volume 8, PDF page 1175.
The documents. The document file? Document file.
What file? Documents volume 8.
Mr. Dave, if Article 370 works itself out and achieves its purpose once the Constituent Assembly for the state of Jammu and Kashmir has completed its task, then where was the occasion thereafter to issue constitutional orders post 1957?
That's for 371 to extend from time to time any amendments. Because there were many provisions of constitution which may not have been made applicable, or many laws which may not have been applicable.
But if you see the proviso to D refers to other provisions of the Constitution, which will apply subject to such modifications. Then matters which are referable to the IOA require only consultation.
Yes.
All other provisions of the Constitution require require the concurrence. That's the second proviso.
Right.
Then the sub-article 2, clause 2 says, if the concurrence has been given before the Constituent Assembly has given its opinion, then it has to be placed before the Constituent Assembly for its opinion and for its concurrence. So your whole argument is that Article 370 has now worked itself out once the Constituent Assembly completed its task. But that would be belied at the least by constitutional practice, because even after 1957, there were orders which were issued, constitutional orders progressively modifying the provisions of the Constitution in relation to the state of Jammu and Kashmir. Which means that, really speaking, Article 370 had continued to operate even thereafter. Therefore, it would not be correct to postulate that Article 370 achieves its life, and what is a temporary provision really assumes a state of permanence in the Indian constitutional fabric.
Lord, may I respect?
Because then there was no question of us, of any constitutional orders being issued progressively from 1954 onwards, or
Article
1958 thereafter.
refers to those decisions which were taken prior to its constitution. So to that limited extent, Constituent Assembly's approval was sought for. But Lord, subsequently, once the Constituent Assembly Lord goes, Lord, whatever, my respectful.
But then where is the power to alter the constitution at all?
Lord,
If your argument is right,
Lord,
then once the Constituent Assembly in 1956-57 takes its decision, there is no power to change any provision of the Constitution in relation to the state of
No.
Jammu and Kashmir,
I respectfully.
which is contrary to what everyone accepted that
373 is only in respect of Lord continuation of 370 or not. Now, Lord, they agree. Constituent Assembly agrees. Once it agrees that it has to be continued, then it becomes Lord some kind of a permanent decision. Please permit me to reread that Lord, 373. Notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications from such date as he may specify, provided that recommendation of Constituent Assembly of State in clause D shall be necessary before President issues such a notification. So, Lord, idea is that you have to decide as a Constituent Assembly whether you want this relationship to continue or not. So, Lord, they took that decision.
No, what I was trying to refer to is this. Clause 2 of Article 370 refers to a decision. It uses the expression decision. The proviso to Clause 3 uses the expression recommendation. But the commonality between Clause 2 of Article 370 and the proviso to 370(3) is some decision or action on the part of the Constituent Assembly. Just give me a minute. Both require some action on the part of the Constituent Assembly. Clause 2 requires a decision, and the proviso to Clause 3 requires the recommendation. Now, according to you, once the Constituent Assembly completed its task in 1957, there was no question thereafter of invoking the proviso to Clause 3, because then it's worked itself out, and the substantive part of Clause 3 and Article 370 becomes a permanent feature of the Constitution. That's the submission. It's a submission worthy of consideration. Absolutely, we have to deal with the submission. I'm just trying to explore that submission. There is one internal inconsistency in accepting that submission, because if that submission is right, qua the proviso to Clause 3, then the consequence would be that once the Constituent Assembly completed its task in 1957, there could be no amendment to the Constitution at all under Clause 2 of Article 370, which is belied not merely by constitutional practice, but the acceptance by both the state of Jammu and Kashmir and the government of India that amendments were being made to the Constitution even after 1957 and until the disputed amendment of 2019.
Just see sub-article 2.
Yes.
If the concurrence of government of state referred to in para 2 of subclause B of clause 1 or second proviso to subclause D of that clause be given before the Constituent Assembly is convened, it's purely limited.
It shall be placed before the Constitution.
Before. So, Lord, this is temporary within temporary. It is in respect of a situation where Lord, the Constitution now, a state has just come in, India is now become a republic, Lord, Constituent Assembly is going to be convened soon, and if some decisions are taken to protect them, that government may do anything it wants to, state government. It may give its concurrence and its consultation, but it should be very clear whether people want it. So they said, if you have done it before, then place it before the Constitution.
But then would the power of the state government to grant its concurrence under the second proviso to Clause D continue to operate once the Constituent Assembly completed its task in 1957?
Lord, what has happened is that government also has said in their affidavit, and
Or would that power be exhausted once the Constituent...
all provisions of the Constitution They have applied all provisions of constitution by 1954. So really speaking, there is nothing left to be done. It is fully in operation now. 370 is
Exactly.
fully in
But
operation.
then that is exactly.
We
but
are talking about
You're right,
repeal.
absolutely logically. But then why? How do we explain the fact that there were subsequent amendments to the constitution by the constituent orders?
What-
Because the provisos to clause D refer to state government. Clause 2 refers to the constituent assembly. And clause 2 says if the consent of the government was taken before the constituent assembly was formed, you have to place it before the constituent assembly.
But a wrong practice cannot result in
No, but
rewriting
sir,
the
we are talking
constitutional
of-
provision.
We're talking
Yeah,
of a practice over what? Over
But
46 plus 18, 64 years.
64 years, after 64 years, you can repeal it. But with great respect, the same argument, it means that 373 can't be repealed. Then you continue with the practice. It's nobody's case.
That's completely out.
It's
But otherwise, you will have to
different
say,
argument.
not, it is not
you will
petitioner's
have to
case
say
that
that-
no longer amendments of constitution can apply. That's not petitioner's case. Question is, what is it that was not supposed to have been agreed, a promise?
if the power under the proviso to clause 3 has exhausted itself, then equally the power under the two provisos to clause D has also exhausted itself.
From moment
In which case, how do we explain the exercise of that power for 64 years?
looking at 373 independently of 371. 372 has no application now. It lived its purpose. Because by its language, it says that if any decision was consultation or concurrence was given before we came into existence, you please come back to us and our decision will be final. That's ended now. So 372 is dead. That's how they wanted it, constitutional framers.
371 survived.
Life to it. Likewise, 373 was also given in a limited sense, and we can't give now life to it. 371 would survive for the purpose of continuing. Your lordships are right. I am not for a moment suggesting conceding on that position. But if it has continued as a practice, there is nothing wrong about continuing that practice. That means that Article 370 is alive to the extent of sub-Article 1. No difficulty about it. Question is, can you repeal it? Can you withdraw it? Do you have power under 3?
But if 370 bracket 1 continues, it will be very difficult to say that 370 bracket 3 ceases to exist. The modality for exercise of the power under 370 bracket 3 is a different issue, which both Mr. Sibal and Mr. Subramaniam and Dr. Dhawan have addressed themselves to. But it would be, because there has to be a logical consistency between how you interpret clause 2 and its impact on clause 1 and the proviso to clause 3. It has to be in tandem. Either everything remains together or everything perishes together.
Then let everything perish together.
But if it did perish, what about the fact that it was applied from 1958 to 2018?
Power,
And there's no power to any of the COs.
What is our submission? My submission is that if you wanted to do it, you do it by constitutional amendment. You have no power. This is a relationship which has been continued for a long time, since 1947. And 371, therefore, continues, your lordships are right, that time and again, Government of India is, President has exercised powers and applied various provisions of laws and constitution from time to time. That's how they wanted it. That's how they wanted it. But it's one thing to continue 371 and it's another to repeal 373. That's the difficulty. Nobody is not saying that the presidential orders extending constitution are wrong or presidential order applying various laws are wrong. People of Jammu and Kashmir want Constitution of India. They want the laws to be applied. So that position, there is nothing wrong about it. But if you repeal it, then that limited power of the state to say that certain laws should be applied in certain manner, that special status, that's
You got the point.
limited.
We'll move on.
Now just see,
Just 1 minute. Just
Please see, Lord, what your lordships are saying is answered in Lord 371B itself, what my Lord Chief Justice is rightly putting. The power of Parliament to make laws for the state shall be limited to those matters in Union list, concurrent list, which in consultation with government of state are declared by President to correspond to matters to so and so, as the matters with respect to which Dominion may make law. So that's futuristic. May make law for the state. So any law that is made in future can be applied by the President under 371B. Then Lord, such other matters in the state list as with concurrence of government of state resident may by order specify. So Lord, this is futuristic exercise of power by the President from time to time. Likewise, Lord, in D, such other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modification as President may by order specify. So power of President is not a surviving power to be exercised from time to time. That is why the words notwithstanding anything contained in the constitution are important in the opening of the article. Now just turn to Mr. Iyengar's broad statement. Please turn to Lord PDF volume.
Away,
My Lord.
whether under the second proviso,
Yes.
D, all the provisions of the constitution could not have been made applicable with the concurrence of the government.
Yes.
So is it not possible that if there is a concurrence of the government under D, the entire provisions of the constitution could be made applicable to Jammu and Kashmir?
There could have been, except 370 can't be.
Except
Lord.
reserve.
Yes, 373 is something which is left to the will of the people. There is no difficulty. Government says
Then
it.
what remains? If everything under the constitution can be made applicable by exercising the powers under D,
Lord, it needs consultation and concurrence.
that's what if
Yeah.
with the concurrence of
Yes,
the question that is being
no
put is
difficulty. It can be, undoubtedly. But the power of Lord removing Article 370 is disappeared.
is a different power.
That's an independent power. And government Lord Union in its affidavit has stated that all provisions of articles of constitution have been made applicable to Jammu and Kashmir. And they have said that there is no difficulty on that. It has worked very well. They say so. There is no doubt that 370 has worked Lord beautifully since 1947. This relationship. There has been no difficulty. It's not Government of India's case that there were impediments in Lord running the administration of the state for any reason, except national security and some violence. They have not given any other reason also. So Lord, this has worked. It must continue to work. Now, why it should continue to work? Please see Lord Professor Dr. Iyengar's broad statement. PDF volume 8, page 1175. The words again, the government of India had committed. Last para at page 1175 minus. Your lordships have got it.
Again, the government of India.
Yes. Again, the government, my Lord
Just one
Justice Call has got.
Just one.
Telling the learned law clerk that they are so lucky that they get opportunity to work with your lordships. When we started practice, each one of us, we didn't have that facility. We all learned on our own.
We are equally fortunate to have their assistants. They're very
The
talented.
quality of assistance they give, especially matters of this nature,
Yes.
it's a Herculean task just to marshal the records, and they assisted tremendously in this.
No, in fact, I had to work hard to get my intern in court today. I wrote a very personal letter to the assistant registrar and said, please, for God's sake, allow them to come in. Because they assist, their assistance is amazing and their experience, but the memories they carry back home are unbelievable. This generation of students are outstanding, these lawyers. They are far more better than my generation was. Again, the government of India have committed themselves to the people of Kashmir on certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with Republic or wish to go out of it. We also committed to ascertaining this will of the people by means of a plebiscite, provided peaceful and normal conditions were restored and impartiality of plebiscite would be guaranteed. We have also agreed that will of the people through instrument of constituent assembly will determine the constitution of the state as well as sphere of union jurisdiction over the state. Now, kindly turn over and please come to Mulot page, the last clause, 8 pages later. The last clause refers to what?